Hi, I hope you guys are doing well in quarantine and staying healthy and getting all of your assignments done and caught up. I have a little video today about legal citation, since we haven't talked too much about it. Some of it will be review, even from 101. Some of it's just some guidelines, some definitions. Hopefully it'll be helpful for the assignment that's due now Thursday on site checking and statutory references. If you need something from me, email me. It's the best way to get in touch with me. If you want to submit your rough drafts early, great. I'll take a look at as much as I can. There are posted in the class tutorials about site checking from Lexis, statutory research rather. There are some site checking references that are really good. There's a short PowerPoint in there that's got some great site checking references, and it's super easy to follow. If you haven't looked at those, take a look at those as soon as possible. But I'm going to give you some quick legal citation quick tips. Okay. You remember from 101 and this class what a citation looks like. So we have this here, Smith versus Allen, and you remember this card says Smith versus Allen. Smith being the movant and Allen being the non-movant. What that means is the movant in a case is the person who's filed it, meaning they have filed the appeal, if we're talking about an appellate citation, or if we're in trial court, it's that they have filed the case. So in trial court, they're the plaintiff or the state in a criminal case. In an appellate court case like this, Smith is going to be the person that filed the appeal. So they probably lost. In fact, they had to have lost at the lower level in order to file something. And so Allen is the non-movant. That means they're the appellee or the person who is being filed against. And you know from the original site that the first number is the volume, the second number is the reporter, the middle part there is the reporter. The second number after the reporter is the page on which the case starts. Then we have the year. For every reporter, you can look up in the Blue Book or the AWLD guide how to cite that particular reporter. Citation is specific, which means that you have guidelines for You'll notice Smith versus Allen is underlined. Every time you see a citation, it's either going to be italicized or underlined. And the Blue Book has important things like where to put the spaces, how many spaces to put. Your Blue Book will also have rules like sometimes see where the year is. You'll see KY for Kentucky. You only see that if you're citing the Kentucky court in a non-Kentucky jurisdiction. So if I'm filing a case, if I'm in Smallville and I'm writing it for an Indiana trial court, but I want to use a Kentucky case as persuasive, I'm going to put KY in there. If I'm in Kentucky and I'm using a KY case, I don't have to do that because most of my cases are going to be from Kentucky, so I don't need to use that. Rules like that for every case and for every reporter are going to be found in your Blue Book. Okay. Tip number 2, Smith versus Allen. The case name is going to be italicized or underlined. You'll see in your site checking quiz, underline it because that's what the instructions are, but Blue Book citation, you can use either italicized or underlined. Rule, the next rule we have. We're going to use first names only, meaning Smith and Jones versus Allen and Brown will become Smith versus Allen on appeal. It's just a shortcut. Another rule, when we have Smith Company Incorporated versus Allen, we're only going to use one business term. So we're going to shorten that to the Smith Company. And you can learn a lot about cases by their caption. So Smith Co., I know that that's a Smith Company. But if it's just Smith, I can be pretty sure that that's a person. There's one exception to that, and that's in a habeas corpus case When you see habeas corpus, that means I'm in a criminal case and I am fighting to be released from prison under a constitutional mandate that says I'm being held unconstitutionally. In that case, the person that I sue is not the state anymore. When the state incarcerated me, it would have been State versus Ziegler. But if I'm filing habeas corpus, meaning constitutionally you can't keep my body anymore because it's constitutional, it's unconstitutional, I sue the warden of the prison I'm in. So that was apparent when we looked at, I think, Roper versus Simmons. Remember that case that we did in 101? Roper versus Simmons was about capital punishment for juveniles. Simmons was our individual, and Roper was the warden at the prison in which he was being held. So Roper, we know that's a person. In that particular case, it is the warden, and that's just the way that it's done in a habeas corpus case. This is Simba because we are not a particularly original family, so the orange cat that we've got is obviously Simba, and because we are not terribly original, we also have his mother, and her name misogynistically is Mama, because we couldn't be bothered with an actual name, which I regret at this point. Okay, so this is the rule that I just said a minute ago. State versus State of Smith, so let's say we're in State Smith or State of Indiana versus Allen, is going to be reduced to State versus Allen. So different states do it differently. Indiana, for instance, is a state, and we use the State of Indiana versus Allen, so it becomes State versus Allen. Kentucky is a Commonwealth. Virginia is a Commonwealth. So they're the Commonwealth of Kentucky versus Allen, which gets reduced to Commonwealth versus Allen. New York, they file cases under the People of New York versus Allen. So theirs gets shortened to People versus Allen. When you see those words, state, Commonwealth, people, you'll know immediately that it's a criminal case. And if you see those words in a caption in an appellate case, you'll know that it's an appellate appeal. Again, if I am going to put the Indiana in the year citation, that's for when I'm citing it outside of the state of Indiana. Cities do the same thing. So city names, they do something different. City of Smith, Indiana gets shortened to City of Smith versus Allen, so we know immediately by looking at the caption that it's a city. The United States, however, always remains the United States. We don't shorten it in any way, unless it's like Commissioner of Revenue of the United States, then we're going to shorten that to Commissioner, but the United States always stays the United States. A few terms that you might see in the cases that you're looking at. XREL stands for on behalf of, and there's lots of different ways that we would see this. XREL on behalf of an incapacitated person, someone who can't file a claim on their own. Sometimes XREL on behalf of a minor child or someone who can't file on their own. In re, it means in the thing, or in the matter of, or regarding. We see this involving children all the time. In re NS. If you look at a case and you see in re NS, that's, you might look at that and think, oh, it's just a bunch of letters. In re means regarding, and NS is the child's initials. We anonymize them for their privacy. In re, a parcel of land. If I have a suit involving jurisdiction over a parcel of land, I'm going to say in re, parcel of land, wherever that may be. Now these are some terms that you're going to see in your cite checks and in your cases fairly frequently. Id and id at. You might be asking yourself at some point, and I've told you this in class, when in doubt, cite. It is not physically possible for you to oversight. Meaning, if you are writing your memos and you put a cite at the end of every sentence, it is not too much. At the end of every word, is the only way that you could cite too often. So don't do that. Nobody wants to do that. Nobody wants to read it. Nobody wants to grade it. But literally a citation at the end of every single sentence is usually justifiable. You don't see that in MLA. You don't see that in APA. So don't think if you cite some sort of cite for every proposition you make that you're going to be, that's overkill. It's just not. This is one way to shortcut that. Id means I just cited that, meaning literally the last case that I cited was the case that I'm still citing. I'm citing or quoting several things in a row, or I'm talking about a case and I want to cite it over and over again. If it is exactly the same case you just cited the very last time you cited, you can shortcut it and say id. You can also use the shortcut id at. So let's say I'm writing about ineffective assistance of counsel, and I'm using the case Strickland versus Washington, which is the case where we get that from the Supreme Court. And I'm talking about Strickland, and I'm talking about Strickland for like 3 paragraphs in a row. I can cite Strickland generally by saying this is the case that we get the standard for ineffective assistance of counsel from. But if I want to quote it later, then I need to say later in the very next line, I would say id at page 265, because if it's a quote, you always have to do what we call a pinpoint cite, which is going to be id at a specific page. But again, that's only if it's literally the last thing you just cited. C, when you are discussing things in the analysis section of a memo, you might say something like, ineffective assistance of counsel requires 2 prongs. 1, that counsel was ineffective, and 2, that it materially affected the representation of the criminal defendant. That's the Strickland test, generally speaking. And I have another human in my house who is running around half clothed, so if this gets not safe for school, I apologize in advance for that. They should know by the running camera and the fact that I'm talking to essentially my china cabinet that something is going on, but apparently they're too busy running around in their skivvies to be worried about my work. So sorry about your luck, students. Anyway, C. So if I'm talking about Strickland versus Washington, and I can say Strickland stands for the proposition that we need these 2 prongs for ineffectiveness. Then I want to cite a whole bunch of other cases that say the same thing, because I'm going to make my point with a 2x4 instead of a toothpick. Great, I can do that. I can also do that to add in some Indiana cases that talk about the standard that we use in Indiana, which is not going to be different, but judges like cases that are from the same state that they're deciding in. So I can say, here's the test for ineffectiveness, Strickland. C, Smith and Allen and Barnes and Robinson and State v. who to who and whatever I want to say. It's when I'm talking about something generally that I'm going to use the C and then list some cases that talk about what I'm saying in order to support my proposition. Then we have something similar which is called but C. If you see this in a case or you want to use it, it's when you are clarifying that not all cases say the same thing, or that there's an outlier case that says something different. So if I've just said blah blah blah, all of this about ineffectiveness, here's the standard, I could also acknowledge to the court that there is a case that is different, and I do that by using the word but C. There's 2 reasons for this. Number 1, grammatically it clarifies that it's not a C, it's not a yes, these are all the same thing, it's a but C. And 2, we have an ethical responsibility to the court to point out when we know of contradictory case law with precedential value. So I can't hide a case. Ethically speaking, I can't make an assertion to the court that that all of the case law is on my side and there's nothing out there that contradicts me if I know that something does. And one of the ways that I can use but C is to show the court that, hey, I know there's some stuff out there that's not on my side. Using C and but C, you can also do a parenthetical. So in your quote, when you have C, all these cases, or but C, Smith versus Washington, you can also put in there a little bit of wording as to why you're talking about this. So if I'm talking about ineffectiveness and I have all these cases and I say but C, Smith versus Washington, I might say exactly the point for which I'm using this case or showing the court that it doesn't show what it doesn't support me. So I might say but C, a case where an attorney fell asleep mid-trial and the court noted that if the attorney was so ineffective that we did not even need to examine whether or not it affected the person's case. So you can say something like that with but C as well. So that's how those two are used. Then finally we have two other terms, supra and infra. When you're talking, like just talking in a brief about a case or a memo about an argument, you can use these two words to refer the reader back to things that you have either talked about previously or are going to talk about in more depth later on. Supra, I've already spoken about it before. See page 3, supra, if I want to refer back to that, or a discussion of the test in this case appears at page 7, infra. You can use these two words for both of those. Okay, so this is a little bit about site checking, a little bit about memo writing, a little bit about some quick tips, a little bit of cat butt, but that's all right. I don't think I've had a video so far or a Zoom meeting without orange cat butt in it. And hopefully this is helpful for you. I'll post a couple more later on in the course. I hope you're all doing well and staying healthy. I miss you guys. Hopefully we'll get to see each other either over the summer or at the end of the course or next semester. Email me at mziegler@ivytech.edu if you need anything, and stay healthy.